Okay, thank you again for joining today's webinar brought to you by the Tribal Law and Policy Institute and the Tribal Judicial Institute, UND School of Law. Today's webinar is titled Criminal Sentencing, Understanding the Parole Process and the Impact on Tribal Justice Systems, and will be presented by Michelle Rivard Parks, Associate Director of the Tribal Judicial Institute, UND School of Law. I will now turn it over to Michelle to introduce herself and to get us started.
Thank you for that introduction, Chantel. Welcome everyone to today's webinar. My name is Michelle Rivard Parks, and I currently serve as the Associate Director of the Tribal Judicial Institute at the University of North Dakota School of Law. In terms of my background, I've taught courses in federal Indian law and tribal law. I have also served as the tribal prosecutor for one of our tribes here in North Dakota. I've also done some legal work for the tribe itself as in-house legal counsel, and currently am also serving as the Chief Justice of the MHA Nation Supreme Court, which is located here in North Dakota. So just a little bit of background and kind of letting you know that, when we start to look at some of these topics related to criminal responses within tribal communities, there's a lot for us to really unpack here. There has been a previous webinar in the series that has been promoted and sponsored through the Tribal Law and Policy Institute, where we did discuss other aspects of criminal sentencing. Most recently, one of the sessions that was provided included sentencing reviews. So when a tribal court issues a sentence in a criminal case, how can that sentence then be reviewed? So in terms of an overview, what we're going to cover in today's webinar is we're going to briefly provide a highlight of tribal court sentencing provisions under the Indian Civil Rights Act. And in that, we will be discussing briefly the enhanced sentencing provisions that followed the enactment of the Tribal Law and Order Act of 2010. We're also going to provide you with some information on what parole is and how it differs from probation. We will then move on to highlight some of the intersections between parole boards and reentry planners and probation departments, as we know that reentry is something that a lot of tribes are now engaging in, as are federal and state agencies. We're then also going to take a moment to look at federal, state, and tribal parole procedures. Of course, when we get to the tribal parole procedures, with the number of federally recognized tribes in this nation, it would be near impossible to highlight all of the parole procedures, but we will provide you with a few different examples of tribes and tribal laws where parole has been incorporated into their tribal justice system process. And so with that, we're going to go ahead and we're going to jump right into today's discussion. And to get us all kind of in, the right framework and thinking on the same page, when we look at crimes that are arising in Indian country, as many of you are aware, the responsibility for responding to crimes is going to fall to one of several sovereigns. It might be the responsibility of the tribe, the state, or the federal government to respond to the crimes that are occurring within Indian country. And sometimes it's a combination of those government agencies that are going to have responsibilities. And so when we look at those responsibilities, one of the things that we know is that tribes are, certainly the predominant government that's going to be responsible for looking out for community welfare and community safety, and in so doing, then will be responding to crimes. And when we look at our tribal responses, and particularly in the criminal sector, we want to give some consideration to what are the sentencing options that are available. And of course, the sentencing options vary greatly. Some tribes have implemented alternatives to incarceration, alternatives to fines. Some tribes have incorporated various services. Some of those might be culturally based or traditionally based services to address sentencing within courts. But what we're going to focus on today are not going to be those alternative provisions. Rather, we're going to take a look at what happens when an individual commits a crime, is adjudicated by the tribe through the tribal court, and is sentenced by the tribal court. We know that there is an intersection in the sentencing provisions that are found in the Indian Civil Rights Act and the sentencing that occurs within many of our tribal criminal sections of our tribal courts. So, first of all, in general, the Indian Civil Rights Act has a provision which states that an Indian tribe, in exercising powers of self-governance, will not impose for a conviction of any one offense a penalty or punishment of a term of imprisonment that goes beyond a year in jail or a fine of $5,000 or both. Now, this has been around for many years, and so a lot of times when we have crimes that are adjudicated in tribal courts, the tribes will be limited in how much jail time an individual can be sentenced to, and that is by virtue of this provision of the Indian Civil Rights Act. Moving forward, however, and in the introduction, I had mentioned the Tribal Law and Order Act of 2010. And one of the things that the Tribal Law and Order Act of 2010 did was it amended the Indian Civil Rights Act. And the amendment was to incorporate what is commonly referred to as enhanced sentencing authority for tribes. And so what this did is when you pull the Indian Civil Rights Act, you will see that prior provision with the 1 year limitation that I just referenced. However, you will also see a section in the Indian Civil Rights Act which applies to offenses that might result in an individual being subjected to more than a year of imprisonment or a fine of more than $5,000 when the crime is adjudicated in the tribal court. And so, for this, a tribal court may subject a defendant or an individual who's been charged in the tribal court to a term of imprisonment of more than a year and not to exceed 3 years for any one offense for a fine of greater than $5,000, but not to exceed $15,000 or both if a person is accused of a criminal offense and that person has been previously convicted of a same or comparable offense by any jurisdiction of the United States, or if the person is being prosecuted for an offense that is comparable to one that would be punishable by more than a year of imprisonment if it was prosecuted in a court of the United States or any of the states in this country. And so this didn't come without its strings, and this enhanced sentencing authority is not entirely self-executing. There were some provisions that were, or some infrastructure requirements, if you will, that go along with this. And there are also some civil rights that go along with this. It included that if a tribe wanted to implement enhanced sentences for these qualifying types of crimes, the tribe would need to have certain things in place, such as providing defense counsel to indigent defendants at no expense to them. That's a little bit of difference from what we see in the other sentencing provisions. There were also requirements that went along about, judicial education and experience. There were provisions that were in there about, making sure that the due process findings were met and made. So this is not entirely self-executing. But we don't want to get too far into the weeds of enhanced sentencing authority. There are some really great resources out there. If your tribe has not yet implemented enhanced sentencing authority, I know that the Tribal Judicial Institute has a PDF publication. It's called the TLOA checklist that you can download, and it goes through all the ins and outs of the Tribal Law and Order Act, of enhanced sentencing authority, what is required for a tribe to put into the justice system infrastructure if the tribe wants to impose these greater periods of incarceration or these higher rates of fines. Additionally, the Tribal Law and Policy Institute has a similar publication that is available on their website for download that will also go through, I believe it goes through enhanced sentencing authority, as well as addresses some provisions of the special tribal criminal jurisdiction under the Violence Against Women Act. But for purposes of our discussion, why are we bringing this up? And how does this relate to parole? Well, the biggest thing is that for tribes that are going down this path of imposing enhanced sentences for crimes adjudicated in tribal courts, what this means then is that we have individuals under those sentencing orders who might be serving more than a year and up to 9 years of incarceration. And as I mentioned when we began today's webinar, this has resulted in some tribes looking at and considering whether or not they need provisions in their laws or procedures and forums to allow for sentencing reviews. So that you may have an individual that's sentenced to 9 years, but perhaps after 5 years, you want to allow that person to have a sentence review or to have that revisited, or maybe to qualify for release from that incarceration earlier than what was contemplated by the judge when the sentence was imposed. And so part of what this sentencing series is kind of been discussing is what are those options? And I had mentioned that there was an earlier webinar that addressed things like pardons and sentencing reviews by the court, commutations, and things of that nature. What we didn't discuss in that prior webinar was parole and what does that look like, and can that be incorporated, particularly by those tribes that are imposing enhanced sentences. Another part of this that we need to be aware of is that, particularly for tribes that are imposing enhanced sentences for qualifying convictions, those individuals, when they're serving periods of incarceration, might be serving that period of detention in a tribal correction center, so long as that has been a correctional facility that is approved and compliant with Bureau of Indian Affairs regulations for longer periods of incarceration. They might also be serving that in a federal facility, or they might be serving that time in a state or local government approved detention facility, subject to some sort of a contract or agreement between the tribe and that institution. And then alternatively, there might be some rehabilitation centers that are have a detention component to them where an individual might be serving these longer periods of incarceration. And that's going to become important to our discussion today, because what we're talking about for today is when an individual has been sentenced and they're serving a period of incarceration, what are some of the options that are available to them, and how might they re-enter the tribal community, and where might they be re-entering the tribal community from? So this all becomes connected. And so, what we want to kind of move into a little bit of a discussion on the impact of sentences, and particularly longer term sentences. And so, I've mentioned that, what our focus of today really is when the tribe is prosecuting or adjudicating a crime, and when the tribal court is issuing a sentencing order, and when the tribe has implemented enhanced sentencing, we have individuals then being sentenced by the tribe to longer periods of incarceration. But once the tribe has concluded the sentencing order, where that individual is housed may vary. With that being said, however, it still will fall back to the tribal court to conduct any sentencing reviews or modifications, or to have parole options within tribal law if it is in fact the tribe that has adjudicated the person and has sentenced the person, irrespective of where that individual is actually serving their period of detention. That jurisdictional authority to review the sentence after it has been imposed is retained by the court that issued the order. So that's important that we have an understanding of that. And that's also why it's important that we start to look at tribal codes to see if there are provisions within our tribal laws or our tribal codes that open the door for those longer term sentences to be reviewed or modified or changed, or to allow for earlier release than what was originally contemplated by the tribal court when they imposed the sentence. And so, when we were taking a look at this, a large part, when tribes were originally contemplating enhanced sentencing authority, a lot of the focus on enhanced sentencing authority related to making sure that tribal laws reflected what was needed in order for the tribe to actually impose the longer sentence. So making sure that tribal codes or laws provided the necessary due process requirements, making sure that those laws were publicly available, revisiting judicial qualification provisions of codes. That was really a large part of the discussion between 2010 and moving forward for implementing tribes. But I think now that we've seen several tribes that have implemented enhanced sentencing, we're now starting to consider that, we might also need to look at amending laws to provide these post-sentencing options for review of individuals who have been incarcerated in criminal cases by the tribal court. And the reason for this review and the reason to consider this might be to effectively support the reintegration of individuals back into the community. Also, I think it's important that we acknowledge that incarceration of individuals, while we might get a lot of people wanting that, there's an extreme cost to detain individuals. And so, if tribes are sentencing individuals to longer periods of incarceration, between 1 and 9 years of incarceration, that can be a significant cost to the tribe. And, the tribe might want to look at whether or not an individual, if they've been sentenced to incarceration for, say, 9 years, and they've done rehabilitated services, and there are a lot of factors that the tribe might look at to say we no longer think this person is a safety risk or a community safety risk. And so continuing to keep that person in that period of incarceration may not be of import to the tribe. And so if you want to have that flexibility within your justice system, it is important to look at the laws that you have and to see if there are post-sentencing options available to your justice system professionals to allow a post-sentence review and a post-sentence assessment for individuals who have been subjected particularly to longer terms of incarceration. And so when we're looking at individuals who are incarcerated, the when and the how they might re-enter the community can vary. There might be times where they've actually served out the period of incarceration that they've been sentenced to. So, in other words, if they've been sentenced to 1 year in jail, they've actually served that 1 year in jail, and then they will be released to the community. They may or may not be subjected to any supervision beyond that, depending upon what the tribal court sentencing order mandated. Also, if we have individuals and we have tribal laws that allow for post-sentence review, sometimes that post-sentence review might require or avail an opportunity for an individual to request the court to review the sentence that was imposed. And if that is an option available under tribal law, an individual who was, let's say, sentenced to 3 years in jail and who applies to the court for a review and successfully pleads their case to the court as that sentence review, they may end up with an amended or modified sentencing order, which may result in their earlier release. Another option that we might see are things like pardons. Pardons oftentimes are going to be issued by government officials that are not part of the judicial branch. It might be, for example, in a state that a pardon could be issued for a state conviction by the governor of that state. In the United States, if it's a federal court conviction, a pardon may be sought and issued by the President of the United States. Within some tribal settings, pardons might work however the tribe wants to set them up, but it could fall to the tribal council, tribal leadership. Perhaps if you have the chief for your tribe or a chairperson for your tribe, your laws might support that individual or that group of individuals to be responsible for pardons. Now, keeping in mind, not all tribal laws allow for pardons, but some do. And another option, which is really what we're going to focus on today, is going to be the parole option. And some individuals who have been incarcerated by virtue of a sentencing order might be released back into the community or re-enter the community through a parole process. And we're going to kind of get into the nitty-gritty and talk about that parole process a little bit. And so community corrections is really kind of a part of what we also need to think about when we're talking about parole. So when we talk about this term community corrections, you can kind of think of that as an umbrella term, and it involves the supervision of individuals and also the connection or provision of services to those individuals while they are in the community. And as such, community corrections options provide alternatives to ongoing incarceration. And we see community corrections reflected through parole, reentry, and probation. So they're all different forms of or part of that umbrella of that we know of as community corrections. And so parole, and we have these different terms: parole, reentry, and probation. Parole really involves this conditional release from jail. So an individual is in jail and they're allowed out of jail on certain conditions, and it happens before they've actually completed the full sentence that the court has ordered them to complete. Reentry is really an important part of criminal corrections. And as we move through today's webinar, you're going to see some intersection between parole and reentry. But reentry really helps to support the reintegration of individuals into the community after they've served periods of incarceration. So reentry, we want to think about that as those are the individual people that are going to help develop plans and plans for services that are going to help people to successfully reintegrate into the community and hopefully not end up continuing to commit crimes. Also, probation is going to be a court-ordered sentence where an individual completes a sentence in the community under supervision. So probation is just a little bit different than parole, and we're going to talk a little bit about that moving forward. But before we do that, we want to talk about what is the purpose of parole. And by focusing on rehabilitation, accountability, and parole really aims to reduce the recidivism of offenders after they are released. And it also aims to foster safer communities. So, and the way that we really do this through parole is it helps by making sure that when a decision is made to allow a person to reintegrate into the community earlier than what their sentence requires, there would be ongoing supervision of that individual while they reenter the community. There would also be wraparound services to support that reentry that would be provided. And so here we start to see this intersection of reentry and parole. And so this can do a few things, but what it can do is it can help to reduce jail overcrowding, and it can help to reduce the costs associated with ongoing incarceration. And as we all know, our justice system costs from the onset of response to a crime through the time of completion of incarceration, through these community corrections, can start to get really high. And so, we're constantly look at trying to accomplish the goals of our criminal justice system in a way that is cost effective while also maintaining community safety. And so what are I kind of mentioned that we would talk a little bit about the differences between parole and probation. Um, Sometimes this gets a little bit confusing because parole and probation in some systems, particularly within state systems, we might see parole and probation under the same umbrella agency. And you could see that in some tribal systems as well. It really depends on if the tribe option has an option for parole and if that's something that's been incorporated into their system. But when we're talking about parole, we're talking about early release. So it's an early release from jail, and it's granted after an individual has served part of a sentence. So let's say that the tribal court has issued a sentence of 1 year in jail. And after 6 months, the individual might be available or be eligible, I'm sorry, to apply for parole. And so really, if you see them when they go through the parole process, they're asking for that early release. And what this also does is it allows for community supervision. So instead of the individual continuing to serve out their time in the incarceration, they're going to complete really their sentence of jail time is going to be in a communal environment under certain terms and conditions. And those terms and conditions for parole are going to be set by the parole board or commission. Now, when we're talking about probation, a part of the sentence of community supervision for probation is actually going to be imposed by the court by virtue of the sentencing order. So, in other words, the sentencing order issued by the tribal court will say that the individual shall serve a period of 1 year in jail, and upon conclusion of serving that 1 year in jail, the individual will complete a 90-day period of probation, which kind of allows that person also to have some sort of community supervision after they have served the period of jail that has been required by the court. So you can kind of see there is a difference between parole and probation. Both are part of community corrections. Both involve over supervision and oversight. But it's really that an individual in parole is going to be an early release, whereas a period of probation is typically going to be something that is part of a sentencing order and can even happen after an individual has been required to serve a period of incarceration. Now, I also had mentioned that parole and reentry are going to have some intersection. And so reentry planners, they may be from different jurisdictions. And some of this can get a little bit complex depending upon where an individual is actually serving out their period of incarceration that was required or mandated by the tribal court sentencing order. Now, you'll recall earlier I had mentioned that once a tribal court has sentenced an individual, particularly to an enhanced sentence, they may serve that period of detention in a tribal facility or a federal facility or a state facility. And there are different factors that may indicate where they're going to serve that sentence, depending upon what detention is available to any particular tribe. Now, a reentry provider is going to typically be working on developing a plan for community supervision for an individual who is incarcerated. And that reentry plan will be worked on while the person is incarcerated and will impact the supervision and services after the individual comes back into the community. So the reentry planners, if a tribe is considering parole as a process or integrating parole, it's going to be really important to consider whether or not your parole forum is going to engage with reentry planners and to do some give some thought to whether what might happen and how that communication may occur if the individual is, say, incarcerated in a state facility by virtue of a detention contract. In that instance, for example, your parole board might need to have some communication with the reentry planner from the state level. It could also be that there's some engagement with a tribal reentry planner. But it's for now, we want you to kind of know that there is an intersection, but with reentry and parole, if you're wanting to plan a parole process. And so how that will work is something that your planner should certainly give some thought to. And one of the important parts of this intersection too is not just, the planning for how that individual is going to reenter, but it's also should they reenter. And so if you're developing a parole process and a forum, ways that reentry planners can help to educate or provide important information that can help guide the parole decision is that reentry planners can help through completing housing plans, providing a plan for social support, which might, alleviate some of the concerns of a parole board, for example, or a decision-making entity. Reentry planners can also complete criminogenic risk and needs assessments and provide some of those results to parole entities to help again guide in their decision-making process. And when we're talking about these risk and needs assessments, these really start to break down and look at what are the needs of the individual, and what are the risks that might lead them back into a life of crime, and that if we meet those needs or we address those risks, we can reduce the likelihood that they would return to criminal behaviors. So that criminogenic risk and needs assessment is something that a lot of reentry planners are doing, but can be very beneficial and helpful to parole boards or entities in making decisions of whether or not to grant an individual parole or early release or not. Others would include completion of substance misuse, mental health, or other treatment programs, and completion of education or vocational programs. Okay, and so when we look at parole, oftentimes and commonly, parole boards are going to serve the function of deciding whether an individual should be released from incarceration early, and what kinds of conditions they should be subject to if they are going to be granted early release. And sometimes, and some jurisdictions have separate parole officers that are distinct from probation officers that will provide the supervision and monitoring as part of community corrections if an individual is granted parole. Other jurisdictions might pass that supervision just to their probation department. And so I point this out again. Is there a right or wrong answer here? I don't think so. But if a tribal justice system planners are considering integrating a parole process, you'll want to give some consideration to who will actually supervise that parole. And will you want to implement a specific position that is a parole officer as part of your community corrections? Do you have a current probation department? Can they serve that function? There, like I said, that's an individual discussion that would need to happen at the tribal level, and one for each tribe to make. Also, it's important when we're looking at parole and probation to understand that usually parole is going to be a decision that's made by a forum such as a parole board. And so if an individual then has been paroled and they have a violation of the terms and conditions of their parole, it's pretty common then that any of those violations would be reported back to the parole board that granted the parole for further action, which is again a little different than probation, which is typically going to be reported to the tribal court or the court that imposed the sentence of probation, and then that would result in a potential probation revocation and further hearing in the court. So let's get into a little bit of the parole process, and I want to just give you an introduction to kind of the federal, a little bit of what we're seeing commonly at the states, and then we'll talk a little bit about what the parole process does look like in some of the tribes that have implemented it. So when we look at the federal process, first of all, it's important to note that federal inmates who were convicted after November 1st of 1987 are not eligible for parole under the federal system. And the reason for that is the federal government passed the Sentencing Reform Act of 1984. And within that act, there are now options for federal inmates who have been sentenced by virtue of a federal court sentencing order to have adjustments made to their sentence for a variety of based on a variety of different factors. So parole isn't something that we're really seeing much of anymore. When you look back, 1987, that's quite some time ago. We probably don't have a tremendous amount of federal inmates who were convicted prior to 1987 still within the system. There are a few, so there is still a U.S. Parole Commission, but again, how active that is, it's not as active as it once was. And some of these Sentencing Reform Act, things that followed was also the First Step Act, which is another federal law that allowed good time credit for federal inmates. It allowed for the transitioning of federal inmates into halfway houses or periods of home confinement to kind of get them out of the federal detention facilities. If people had qualifying terminal medical conditions, it might allow for early release. So federal law kind of made it less subjective, but it does still provide some early release options. It's just that those early release options federally rarely occur by virtue of parole. Within states, many states do have parole options for individuals. It's going to vary, particularly in the procedures, is going to vary from state to state. Many of the states will have a designated parole board. And for those that do, this process usually involves is an application for parole is developed and submitted by an individual who's incarcerated by virtue of a state sentencing order. That individual, they might have to meet some eligibility criteria that is established by state law. And once they meet those eligibility criteria, then they will submit the application to the state parole board. State laws are going to dictate what factors the parole board can look at and consider. State law will also address the process for hearings and decisions regarding conditions that can be opposed if early release is granted. States generally do not notify tribes of parole decisions. However, notifications might occur if the individual, depending on the kind of conviction it is. So, for example, there's entirely different sets of laws that will apply for sex offenders, as we know, that mandate registration and community notification. There might also be state tribal agreements that could be negotiated or entered into so that if a state issues parole and an individual who has been paroled by a state parole board is going to live or work or enter into a tribal community, state tribal agreements might mandate that the state parole board notify the tribe of that early release. And there might also be some federal mandate. So for many states, there will be a Office of Probation and Parole. And again, so when an individual is granted parole by many states through their parole board, they will often serve out or have to meet and be supervised by the state's probation and parole office or department. And so again, you're going to have to look state by state to see what that's going to look like. Some of the common factors that a lot of parole boards will look at, though, in determining whether an individual should be subject or authorized for early release might be to look at the nature and severity of the crime. They might consider the individual's risk of safety to the community and or victim. And recall back, I had referenced like how do you assess that risk? Well, one of the ways might be completion of those criminogenic risk and needs assessments. Many parole boards do allow for victim input. So the victim or the family of the victim might have an opportunity to attend parole hearings or provide written statements to offer their position on whether the individual should be subjected to or authorized for early release or what their concerns might be. Individual remorse for criminal conduct is another common factor that parole boards might consider. The individual's institutional behavior. So during their period of confinement or detention, have they had infractions? Have they abided by the rules of the institution? Have they engaged in rehabilitative efforts that have been made available to them, such as counseling, whether that's group or individual, maybe some educational opportunities, things of that nature. And then also the mental and physical health of the individual who is incarcerated is another common factor that parole boards might consider. And so a lot of the parole systems that are in place, particularly at the state level, will have the parole boards looking at these kind of factors and deciding whether or not the individual who's applied for early release has been sufficiently rehabilitated, and whether they would pose an ongoing threat to the community if they are released. And ultimately, if the parole board finds that they believe there's been sufficient rehabilitation and they don't feel that there's an ongoing threat to the community or a high risk of ongoing criminal behavior, then typically parole would be granted to that individual, subject to certain conditions, or requirements, if you will. And a lot of times the conditions or the requirements that would be imposed on an individual, a lot of times those are arrived at based upon the work and the suggestions of the reentry planners, who have been kind of, following up on the individual and taking a look at all of these different factors while that individual has been incarcerated. Um, so when we're looking at a tribal process, just to be clear, like any jurisdiction, the a tribal parole process, first and foremost, is only going to come into play if the tribal law or tribal code establishes a forum for parole decisions to be made, if the tribal law provides factors that a parole forum will consider, and sets forth a process, for example, an application process, a ruling and decision process, that type of thing. So, if you look to your tribal codes right now and you don't find parole mentioned anywhere, then parole is not an option, even for individuals who might be subjected to longer terms of incarceration by the tribal court. If your tribal law does reflect that, or if you are amending your tribal codes to incorporate a parole process, we know that that parole process that you create under tribal law is going to apply to individuals who have been sentenced to periods of incarceration by the tribal court. So it's not going to apply or get kicked in if an individual is serving a sentence imposed by a federal court or a sentence imposed by a state court. And this is true even in instances where the individual who has been sentenced by the tribal court is actually serving that period of detention in a non-tribal facility. And so, I think it's at least worthy of consideration, particularly for those tribes that are imposing enhanced sentences. And then also, when we're looking at creating a tribal parole process or maybe enhancing a process that you already have reflected in your law, taking a look at collaborative opportunities that might be helpful, if an individual is granted parole under tribal law, is a good idea. And it might involve, having your tribal laws allow for collaboration, and it might also involve the execution of some collaborative documents. So when tribes are moving forward with incorporating parole, we've seen it a couple of ways, and I'm going to try to give you a few examples of this. But we've seen examples of a tribe that has incorporated parole through collaborations with a state. And the reason that the tribe wanted to get involved with parole is because they were seeing high numbers of enrolled members or tribal members in general who were being incarcerated by virtue of state law. And so, one of the examples we're going to give you here is to show you a collaboration between a tribe and a state where the tribe is actually engaging in the state's parole process. Another option is for tribes to engage in the parole process through the development of tribal laws that are going to apply to tribal convictions and tribal sentences, and really is a process then that would support community corrections through the incorporation of parole provisions within your tribal justice system. So I mentioned that one of the options for engaging in a parole process might be through a collaboration. And one example from the field of that is can be taken from the Sistinwaptinoyate, located on the border here of South Dakota and North Dakota. And the Sistinwaptinoyate entered into an intergovernmental agreement with the state of South Dakota in 2014. So this is an example of collaboration. And what it did was it established a tribal parole pilot project. And the idea here was to improve compliance with parole conditions, to reduce the number of individuals who were granted parole from returning to prison or violating their terms of parole, and also was intended to improve community safety and supervision. And part of the way that this was done under this collaboration is it supported the establishment of a tribal parole office. And that tribal parole office was managing the caseload of tribal members who had been released on parole from the South Dakota State Corrections Facility. So this is kind of a unique collaboration in the sense that this applies when we've had a tribal member who was convicted under this by the state of South Dakota, who was incarcerated in a state facility, who applied to the state's parole board, who was granted parole by the state parole board. But then the state parole board is collaborating with the tribe and having the tribal parole office supervise that individual while they are out on parole. And in doing so, then the tribal parole office would be linking those individuals to community services and other things that would help that parolee to not commit another crime or otherwise violate their parole or probation. And I don't have any hard information on the success of this program, but it is certainly an interesting example of how a tribe might engage with a state to address parole and the supervision of parolees, even if that individual is not subject to a tribal sentencing order. Now, that said, there are provisions within tribal laws that do reference parole within the tribe's own justice system. And so, one example is from the field is Shoshone Bannock tribes of the Fort Hall Reservation. They do have a definition within their code of what parole means in their criminal justice system, and that it means the conditional release from prison of a person who has served part of a sentence in an institution. One thing is that although parole is mentioned in the tribe's code, there's no defined process within their code for how whether an individual can apply for parole from the tribe and what that might look like. But it is important because there might be other code provisions that talk about or regulations that a tribe might have that will say, for example, an individual who's on probation or parole is not eligible to attend community events or something like that. And so it would be important then for the tribal code to at least define what parole means. So this is an example where we've got kind of that definition of parole within tribal law so that we're clear and we have an understanding that this is a process that is involved in a criminal justice system, although here it does not particularly carve out an internal process for the granting of parole to an individual who has been subject to a term of incarceration by virtue of a tribal court sentencing order. Another example from the field, however, does take things a little step further. So, Turtle Mountain Band of Chippewa has several provisions within their tribal code that go a little deeper into the parole process. And they have a section that talks about the eligibility criteria for parole. So, under Turtle Mountain's law, an individual who has served at least one half of their sentence without any misconduct would be eligible to be considered for parole. And under their tribal code, they have to, if they want early release by virtue of the parole process, they apply to the court for that. And then the court will consider, these factors under tribal law, and they will decide whether or not to grant parole to an individual. And in their law, the tribal prisoner's criminal history, the prosecutor's office is going to be consulted, and the correctional department would also be consulted before the judge would issue a decision. So it's a little different here because for a lot of states, for example, the decision of whether to grant parole or not goes to an independent forum like a parole board. But as you can see, Turtle Mountain, in their sovereign authority, has vested their tribal court with the authority to grant parole. And it's really up to each tribe whether you would want a separate parole forum, such as a parole board, whether you want to do what Turtle Mountain has done and vest that authority with your tribal court. And so, under tribal law with Turtle Mountain, also, if the court grants this early release, it would be a conditional release, and the court would then impose additional requirements that would apply to their early release and their supervision during that early release. Another and the last example that I'm going to provide you with here as we're just kind of closing things out on our webinar today is an example from the White Mountain Apache tribe. And so as Turtle Mountain had the authority for parole and the application go to the tribal courts, White Mountain Apache tribe gives us an example where they've actually established under their law a parole board. And it's the parole board that will hear and adjudicate any of the post-sentencing motions of inmates. The parole board would hear some of these particular types of cases where there's an early release request. If there's 2/3 of the sentence that's been completed, they also will address suspension of sentence and temporary releases. And so it's a little bit different process than what we've seen at Turtle Mountain. Under White Mountain Apache tribal code, also their parole or their law reflects who will be a part of the parole board. So, in some states, for example, there might be appointments to a parole board. Under White Mountain Apache Tribal Code, the Department of Corrections director and supervisor and a detention officer that are appointed by the director and supervisor will comprise their board. How you might want to comprise a parole board, if that's something you would want to do, would be completely up to you. The White Mountain Apache Tribal Code goes a little bit further. It kind of goes in and talks about and directs what is going to happen at a parole board meeting, how they will make their decisions, some of the conditions, or if there's opposition that has been filed, they'll consider some of those factors. They will consider also infractions during the period of confinement and disciplinary actions, those types of things. They're also going to review some of the comments of parties as are further outlined in their code, and their law indicates that it must be a majority of 2 of the 3 parole board members have to approve in granting a decision. So it doesn't require a unanimous decision be made by their parole board, rather a majority decision. And again, that's up to each tribe how they might want to fashion that decision-making authority. But I wanted to kind of point this out, all of these examples out to you so you could see how you might engage with a state to collaborate, particularly when you've got individuals who are community members and are being sentenced and maybe paroled and coming back to your community after a state conviction. But I also wanted to show you some examples of tribal code provisions where we see parole referenced and what that might look like. So just a couple final points, as I know we're kind of coming up on our end here, is that, one of the points of today was really to talk about, particularly for tribes that are imposing enhanced sentences, what you want to look at in that post-sentence review options, whether parole might be a process that you want to consider implementing under your tribal laws. Um, and then if you do, if you're going to implement that, whether you want a forum for that, whether you want to vest that authority with your court or some other individual, and then what does the supervision look like if an individual is granted parole? These are all kind of factors that you would want to take a look at. And the approach you take, or, whether you decide parole is right for you or not right for you, whether it's a necessity or whether it's not, and then what you want the process to look like. It really could vary depending upon the number of people that you are incarcerating through your tribal courts, what the average length of those periods of incarceration are currently, what that cost is to the tribe, what kind of services are being made available to individuals to support their rehabilitation during periods of incarceration. All of these are factors that you might want to take a look at in assessing whether or not you feel like parole is something to address within your tribal law. And hopefully from today's discussion, if you do decide that parole is something you want to integrate, you'll have an better understanding of parole, how it's distinguished from probation, and what kinds of provisions you might want to look at addressing within your tribal codes to successfully implement and integrate parole into your tribal justice system. So with that, I think I'm up on time here. We're about 5 after the hour, and I would at this point open it up to any questions that anyone may have.
Thank you, Michelle. I am not seeing any open questions currently. If anybody does have any and you want to quickly put those in the chat or the Q&A box, we can answer those and give you a couple of minutes to do that. Otherwise, we can probably go to the next slide as well, and we can also look at doing the QR code for evaluation. But again, if you have any questions, please put them in the chat. If not, and you think of something later, you can email us. Our email address is there on the screen, as well as the contact for TJI. We would be happy to answer any questions that you might have later on if nothing comes up currently as well. But I do want to also just again say thank you for attending today's webinar, Criminal Sentencing, Understanding the Parole Process and the Impact on Tribal Judicial Systems. And say thank you again to Michelle Rivard Parks, the Associate Director at the Tribal Judicial Institute at UND School of Law, for joining us today. Again, the webinar recording will be posted on walkingoncommonground.org and will also be sent out to our mailing list. We do have the evaluation link dropped in the chat box as well. And also, I wanted to note that this webinar is part of a series of monthly webinars to support the development and enhancement of tribal courts, tribal judicial systems, and intergovernmental collaborations. These webinars are brought to you by the Tribal Law and Policy Institute, the National American Indian Court Judges Association, and the Tribal Judicial Institute UND School of Law. Our next webinar will be titled Judicial Ethics and Professionalism in Tribal Courts. And currently it will be scheduled for the end of October. And once available, the registration link and information will be shared out by email along with today's webinar recording and materials, or in a separate constant contact email. And again, there is a link for an evaluation in the chat box, as well as the QR code on screen. And we would appreciate you taking a moment to fill that out. And again, thank you for joining us today, and we look forward to seeing you next month.